Wow, there we go.
We're going to call to order tonight's special city commission meeting for July 13th, 2026. Roll call, please.
Mariano?
Here.
Commissioner Tipton?
Here.
Commissioner Scrivener?
Here.
Commissioner Leachman?
Here.
Commissioner Wilkinson?
Present.
So we've got two items on our agenda tonight. We have an executive session on there. We're going to move that, and Ashley will explain. We may or may not need to take an executive session, so we're going to move into consideration of an ordinance in the city of El Dorado, Kansas, prohibiting the installation and operation of high-impact data centers and Tier 2 and Tier 3 battery energy storage systems to protect health, safety, and welfare of the residents of El Dorado.
Okay. Thank you, Mayor. Thank you, Commissioners. As the agenda item suggests, there's a specific matter before the commission this evening. Before we get into it, the substance of that, there are a few things that I want to sort of make sure is on the record publicly, especially as this topic has generated a lot of discussion, a lot of commentary, those types of things. And there are some limiting options, especially for city council, but for the city itself, and as it relates to addressing or responding to some of those things. So if you'll bear with me, I just wanted to take a minute to give some clarity on a few things that I don't know that we have been as clear about. Specifically, there seems to be, at least from my perspective as the city's council, a disconnect between the idea about what social media or commentary or those types of things are asking for and what the current situation actually allows of city staff and of the city attorney and of the commission themselves. So for clarity's purposes, so that the commission knows and so that the community knows, in my role, in my seat as a city attorney, it is not only not my job to have an opinion on what should or should not come to the city of El Dorado. I'm not technically or legally allowed to give that opinion. It's a policy issue. In my job, in my role as an attorney, I give legal advice. And then policymakers and decision makers and people who are elected into that role, that is within their purview. So when we take on a role like this one, if the question is, there's not a lot of clarity around whether it be David's opinion or mine or city staff's opinion, we are obligated not to take a strong position or stance on that. And I just want to be clear that it is not as a mechanism to hide anything. It just is truly the way that our jobs are created and framed. The second thing that I think requires some clarity, and you'll understand why I'm saying all of this on this record in a moment, is that as city attorney, there have been concerns or other things addressed that my firm or myself represents El Dorado Inc. I have no legal relationship whatsoever with El Dorado Inc. My firm does not represent them. We've not served as their counsel. We've never served as their counsel. So there's no conflict concerns there as it relates to anything that El Dorado Inc. may or may not be doing versus how the city is advised. The only other comment that I wanted to make before we proceed on this specific topic is, and again, I can only gather what I understand to be misinterpretations or misconceptions about something based off of what is being discussed on social media or otherwise, especially as it relates to in the city's social media comments, because I can't have these conversations with original or existing community members, which I'll explain to you all in a second. But what I think deserves clarity is that a non-disclosure agreement, there's been lots of talk and lots of discussion about the existence, the non-existence, and what it can and cannot do and how it limits this commission and what this commission can do. And for clarity's purposes, the non-disclosure agreement, the existence of one and what they exist to do is that they're not a contract or commitment to do anything. It's not an approval. It's not an agreement to move forward with anything. It's a means for two parties while they're having a discussion, an exploratory discussion about whether or not something is or is not appropriate, that whatever confidential information may be shared as it relates to that discussion is not shared outside the bounds of that. It is the way people protect their own confidential information. It is a way to keep the conversation moving without sort of alerting the idea that these conversations are happening. And the reason that I am indicating this or talking about this tonight is, again, because I think that it's important that the city have the ability or the mechanism to sort of see the concerns that are happening in the public or see the continued discussions, and they're based on incorrect assumptions or they're based on incorrect facts. And so I just wanted to give clarity around those sort of existing pieces as we move forward. So what is in front of the commission tonight, as the mayor has said, is a petition ordinance. So for the timeline of where we are, where we have been and where we are today, June 1st is when the zoning text amendment was adopted by the city commission. That's in the current code. That established the framework for emerging industrial uses. On June 22nd, a citizens ordinance petition was filed. On June 26th of 2026, that petition was certified as sufficient as it relates to the necessary signatures and verification process. That puts the statutory deadline of the 20 days and for this commission to make the next choice as it relates to that as July 15th. So we're within that timeline and that frame. On June 29th, there was a special meeting held by the commission regarding the ordinance petition. It was an executive session to discuss how the petition was filed and what legal options were available to the commission as it relates to the way and the mechanism and the vehicle that was used to present the petition to the commission. On June 30th, after having alerted the commission to what I believe to be significant and foundational legal concerns with the way that the ordinance petition is drafted, I immediately reached out to the attorney that drafted the petition. I sent an email and I said, hey, these are my concerns based on what Kansas law says and the way that these ordinance petitions have been reviewed by the Kansas Supreme Court. I have concerns about the vehicle that you're using in order to get this through to the next level, whether it be through an adoption or a special election. I invited the attorney at that time to sort of tell me what if I was missing something, if there was an area of law that he had clarity on that I did not, any of those things, because I wanted to invite discussion and I wanted to invite transparency at that point in time so that it didn't blindside anyone when we would show up to a meeting and I would give sort of our legal opinion. On July 7th is when I received his initial response. I reviewed it and I said, you know what, I want to give you the opportunity to prepare whatever it is you want the commission to see as it relates to your legal analysis versus what it is that I have shared with the commission and that I will share at the meeting. He was inclined to do so, and so on July 8th, he sent me a formal letter sort of spelling out his argument. That's what you see in the agenda packet itself, is I had identified the concerns I had with the validity of the petition, and I wanted you to have full context of what his review of that is. The reason that I'm spelling all of this out for you is because I don't want anyone in the room to otherwise be blindsided by what it is that I'm going to share with you, with the room publicly, and again advise you all at this meeting today. My rules of professional conduct state that when I know that a party is represented by counsel, I cannot communicate with that party. I can only communicate with their lawyer. So when questions start to arise about what are the city's legal concerns, what is happening, all of those things, I reached out to the attorney and said, hey, I just need clarity around who it is that you represent. So to the extent someone in the community wants to speak or get clarity or have conversations with me, I know who is represented by counsel and who isn't. The city, or the attorney, told me that he would decline to identify his client and for the city to consider anyone that has ever spoken up at a commission meeting as it relates to the data center issue was a client of his, which I appreciate, except that it created more of a complex issue because then I can't engage at all with anyone that was otherwise involved or have a discussion at all or respond to the comments on the city's Facebook page, questions, anything like that, because it creates an ethical issue for me which is why I sort of wanted that clarity. So if I could give conversation or have transparency in that aspect, I would be able to do it. But because that was the mechanism in which he wanted to continue having this conversation, it sort of eliminated any ability to have this conversation outside of this room. So the reason that I explain that here is because nothing that was done on behalf of the city as it relates to the analysis and the work that we're going to go through tonight, I wanted to be a surprise. It was not done in secrets. That attorney's clients were entitled to know what their attorney had been told on the 30th when I explained those concerns. To the extent that they don't know, or that hasn't been adequately communicated to a group of people, that's just outside the city's control, outside our ability to communicate that in any way. So I want, as we are making sure that we engage in processes here with as much clarity and transparency as we can, I just wanted to let the commission know that I did engage with the attorney that drafted the petition. I did engage and ask questions. I did encourage him to communicate with his clients and make sure that they were well informed and understood sort of the concerns that I was having coming into this meeting. So that brings us to tonight, which is the commission meeting in which we're going to sort of go through the ordinance petition and talk about options. So the issue that I identified for the attorney that drafted the original ordinance is that I have a threshold legal question about whether the petition, the way that it is drafted, is legally appropriate under the statutory scheme that allows ordinance petitions to be used. Again, for clarity, it's not a discussion about whether or not myself or city staff think that data centers are good or bad, or about whether battery storage are good or bad. This is an advocacy around the actual topic of the petition itself. It is a legal, technical concern. The initiative petition process set out through KSA 12-3013 allows for citizens to propose new laws by gathering signatures, but it only reaches legislative acts, so things that are genuinely new policy choices. It specifically accepts anything that is an administrative act. An act is specifically exempted out of that statute. So then we have to ask whether something is legislative or administrative, and unfortunately, like lots of areas in Kansas law, it's not a straight label. We have to apply a test. So the Kansas Supreme Court has set out a 4-guideline test that courts apply to the facts of each case. There are 4 tests: whether the measure makes new law or carries out or addresses an existing framework that exists already in the city's code, whether it addresses a broad new purpose or a piece of an existing scheme, whether it requires specialized municipal expertise, and whether it touches a matter of statewide concern that the legislature has already delegated to cities. Usually, in most cases that have come before the Kansas Supreme Court on a question of whether or not a petition ordinance is legislative or administrative, if it applies to zoning, it almost always comes out as an administrative type of ordinance. The reason for that is because Kansas has a comprehensive statutory framework governing how cities zone, how planning commission reviews for notice and public hearings under a separate statutory scheme. So usually a zoning measure isn't a city writing, it isn't writing policy on a blank slate. The city is using the scheme that the legislature created for it in order to use zoning uses. There's the Kansas Supreme Court case that I specifically raised and have concerns with, the citizens used the same petition statute to restrict the city's zoning and condemnation decisions, and the court in that case ultimately held that those measures were administrative and outside the scope of what the petition could do. The specific problem with this petition as it was drafted is that it ties itself directly to the city's zoning code. So it defines what it prohibits by zoning district and land use. It enforces its prohibitions through the city's zoning regulations. So the enforcement mechanism of the ordinance as it's drafted uses the city's zoning code in order to enforce it. It also, on its face, declares that it overrides any conflicting part of the zoning code. That language is in the ordinance text itself. So again, when I first identified this as a concern, I obviously explained it to the commission, and then I reached out directly to the lawyer and I said, I have concerns about the way that this ordinance was drafted. I think that it falls squarely within this based on Kansas law, but I certainly, if I'm missing something, or there's a mechanism in which to reframe it or to approach this differently. His response didn't alleviate those concerns. He essentially took the position, as you can see in the letter that he drafted for the commission, that the ordinance itself doesn't deal with zoning at all. It's not a zoning issue. It's more like a rule, like he compared it to like a rule against setting off fireworks, that it's not necessarily against zoning, it's just the city of having the ability to use its police power in order to make rules for the city as a whole. The problem is that his position now and the way that the text is drafted are in conflict. An ordinance cannot be built on the zoning code, enforced through zoning code, and written to override zoning code, and then also be something that doesn't have anything to do with zoning. The document itself and the way that he drafted the ordinance and the argument that is now being made, I believe, are in contradiction. I don't think that the way that this petition is framed around health and safety takes it out of zoning, even if it's just specifically because of the way that it was drafted and the way that it specifically refers to the zoning code in order to enforce it. The petition attempts to decide land use eligibility within the city limits, what can be built, what can be operated, and what cannot be. It is my opinion that those are squarely within the frame of zoning decisions. Under the law, my analysis is that this is exactly the kind of decision, this type of zoning that has to go through the zoning process, not the ordinance petition process. It does not mean that the city cannot act on the concerns behind the petition. The city commission can. There is a lawful process for addressing these concerns. And if the will of the commission is for the city to do that, then that's the direction that city staff will take in order to effectuate the impact in this ordinance petition through a legal mechanism that doesn't contradict what Kansas case law suggests that we can and cannot do through this vehicle. So my recommendation is that the city not proceed with this particular petition in its particular form through this process, because I don't believe that the law permits the commission to do so. But that recommendation is squarely about the process in which we get to the end result. It is not about what the end result is. If the commission wants like I said, if the commission wants a zoning amendment to the zoning code that effectuates the work that has been done to create this ordinance petition, we can do that. And I have options in which that we can reach that same result. My recommendation to you is that you do it through the legal mechanism, the way the Kansas law allows for that to be done, as opposed to ignoring it. So the threshold question that I would have for this commission as we work through the options is the question underneath what happens next is whether or not the commission wants to restrict or prohibit the uses beyond what has already been established in the city's existing text amendment to the zoning code. We need to sort of get direction on what the commission is thinking, because the path forward wholly depends on what direction the commission wants to go. The best way that I could think through and describe sort of what the options are here is sort of two distinct branches. If the commission is open to, and the will of the commission is to restricting these uses, then there's a lawful way to get there. And I have a process in which we can do that, that exists through Kansas law. If not, if that is not the will of the commission, and that is not the direction they want to go, then the question becomes a little bit narrower today about what the commission intends to do as it relates to this specific petition. So, if the will of the commission is to restrict use in line with what the ordinance petition seeks to accomplish, in what I would argue is the most legally defensible way, which means it is within the appropriate mechanism of the statute. It follows the statutory scheme that already exists by the legislature in order for the city to effectuate zoning. Then the cleanest path to do that would be through using our own zoning process. It would be the same process that was used for the initial text amendments. You would direct city staff specifically about wanting to effectuate the impact of this zoning ordinance. Goes to the planning commission, public hearing, moves for a vote here. If the concern is timing between that work that needs to be done and right now, there's an option, which I'll let sort of David speak on in a minute, about putting a moratorium in place during that timeline so that we can ensure that there are no projects or anything proposed in the interim, to make sure to go back and to sort of give the confidence and the assurance that while we try to reach the end result that the ordinance petition is attempting to effectuate, that nothing else will be considered at that time. From my mind, this gives the community the outcome, those that sign the petition, the outcome that they're asking for, but through the legal process that I've advised to you, I think is the most appropriate one. My only caution here is that it only works if that is the ultimate goal of the commission. The residents and the individuals who signed the petition and moved this petition ordinance forward, they want real restriction. They want it to be very clear on its face that is the plan. So it needs to be a genuine commitment to get through that process as cleanly and as legally defensibly as we can. If the commission is not there or not sure, then an alternative option would be we need to address the petition as it exists right now. Option one would be to decline the petition as a valid exercise of the statutory scheme. This is the position that I've laid out, that the mechanism in which it has been used, the vehicle to get this ordinance here, is administrative and therefore outside the petition process. I will be honest with you, the lawyer who drafted the ordinance has made it clear that if the commission declines to treat the petition as valid and treats it as an administrative petition as opposed to a legislative one, he has indicated that the city will receive a lawsuit, which I think it is I understand that sort of being, he's taken the position that this isn't administrative. What that looks like is likely a DEC action, a declaratory judgment action, in the district court, and the city's response will be what I just largely explained, which is, hey, this doesn't appear to us, based on the text of the ordinance that specifically relies on the zoning code to enforce it and to understand it and to define it, it appears to be outside the appropriate process. The option two is sort of two options in one. Obviously, by the statute, if you are inclined to treat the petition as a valid petition under the statutory scheme for ordinance petitions, your options then are to adopt it as drafted. There can be no changes, no amendments, nothing like that. You have to adopt it as drafted, or you can send it to the ballot, again, as drafted, no changes, no revisions. There may be there may be no sort of revisions. It has to be presented on the ballot as it exists. That would happen at the general election, right? So we would have to, at the next meeting, just have a resolution, put a resolution in front of the commission to put it on the ballot, and then it would be on the ballot in November. One of the things I want to flag under that option is that there are inconsistencies with the way that the ordinance is drafted in our existing zoning code. It doesn't fully cover what exists as it exists now, but because of the way that the ordinance petition statute reads, it would be really difficult to clean that up on the back end because the city is not allowed to touch any of the zoning that would otherwise relate to or be connected to the ordinance petition for 10 years or has to put it back on the ballot. So the sort of disconnect or discrepancies between what the zoning text amendment says and the ordinance petition and the gaps that exist there would be difficult for us to fix or amend. It likely would just be a really messy area of the code. One of the other tools that we talked through during June 1 was whether or not the commission was interested in or wanted to entertain the idea of a moratorium. At that time, the commission chose to adopt a framework that let uses be reviewed case by case with discretion so that each location, scale, design, and impact could be weighed on each specific project. At that point in time, the commission's decision was to go ahead and pass the text amendments. At this point, obviously, there is a ordinance petition in front of you to have tighter restriction there. So if that is the direction that the commission wants to go, one of the things that David has been working on and has put together is an option for the commission to pass a moratorium in the interim so that whatever needs to happen between today and whether it be it goes on the ballot or there needs to be a new zoning amendment direction from the city down, that the moratorium can give some peace of mind to those individuals who have put the effort into executing the ordinance petition. Yeah? Yeah. So I think what is important, at least at this point, because I know that the things that I've told you, the things that I've explained, are not going to make me very popular, but it's my job to tell you what the risks are and what the implications of doing things one way, even though the law says to do them another way. But what I will say is that just because I believe that this petition is not a valid legal vehicle to get to the end result doesn't mean that I don't think the effort behind getting the ordinance petition to this place doesn't count. Obviously, hundreds of people signed the ordinance petition. They spent their time trying to be heard on something that they care about. They have put a lot of effort, time, and energy into making sure that they are heard and that their wishes about what happens within the city limits are important. So again, for clarity, the distinction I'm drawing here is that it is with the legal mechanism in which we got here that is my overarching concern and why my recommendation is to not declare the petition as valid as drafted, because I don't think the tool can lawfully do what it's being asked to do, not because I think that the sentiment is the incorrect one. So I want to open this up for your discussion and let you guys discuss the options and talk through what you're thinking. If at any point during the discussion a question comes up that would require me to give you legal advice about litigation risk or legal strategy as it relates to a lawsuit, I will stop and suggest that we go into executive session. I cannot legally advise you about those types of things on the public record. But any conversation as it relates to policy discussion or what the ultimate decision is, we will discuss out here. And then once we kind of understand the direction, we can give you next steps about what that direction looks like. I just don't want to put the cart before the horse.
I have a question going clear back to where you started this, just so that we are aware of here. You had made comment about the inability to comment based on not knowing who his clients were. Would that be on the flip side as well, as it relates to emails and things of that nature for us going forward now that attorneys are involved? Okay.
Yeah, yes, so technically, parties who are represented can communicate outside of council. Typically, they're advised not to, just because that means we have, a bunch of things crossing when they shouldn't. Yeah, typically the city's policy is that once a party is represented by council, then their council needs to communicate directly through legal counsel for the city.
Okay.
And that's to protect the city, to protect city staff, to protect the process. Yeah, did that answer your question?
Yeah,
Okay.
yeah, I just wanted to make sure, I know sometimes I've gotten requests to meet with people about this topic and things, and just want to make sure that now that we know what that looks like, we don't get ourselves in a situation that isn't appropriate for
Yeah.
everybody.
Yep,
So, okay, thank you.
yep,
And so the direction from the other legal counsel is that everybody is his client?
correct. Yeah, so his responsibility then will be to communicate with his clients.
Sure.
So whomever they are, if they are not getting clarity or communication, even though we are communicating with him, if they're not getting that information, we can't control that. What we can control is if they're represented by counsel, we can communicate through counsel, and their expectation should be that he communicates to them.
Okay,
Understood.
okay, thank you.
Discussion up here.
Yeah. No, I mean, there's several notes that I took here, but one of the things that really stood out to me that is of concern is that this is something that's locked in for 10 years and cannot be changed, and I don't think that, the city's often and always looking at their zoning policies. I think just a few months ago, we passed 5 changes to our policy, to our zoning regulations that didn't have any pushback or anything. So it's something that the city's constantly looking at, whether, it's as popular or not. And so the idea of locking something in for 10 years that can't be changed, that's a concern for me, for sure.
Ashlyn, if this petitioned ordinance were to either be passed tonight or sent to the special election and passed, and it was later found that that was not the correct legal vehicle for doing so, are there any legal repercussions?
Yeah, it's hard to predict what specifically those legal repercussions could be because it truly depends. Ultimately, what would happen is if the ordinance or the code is challenged after it is adopted and or passed through the election, whether or not the city agrees or disagrees with the person who is challenging it, our obligation would be to defend it, because it is, we can't change it. It is created as city law. What I will say is one of the reasons that the Kansas Supreme Court was really clear and enumerated why zoning regulations are administrative historically and exempt from the ability to do through the ordinance petition mechanism is because it does take experience and sort of knowledge and like specialized institutionalized knowledge as when it comes to zoning, right? It's not, it is something that is within the, whether it be staff or all of those things, it is not something that is just sort of common everyday experience that people are drafting and enforcing zoning regulations. So one of the things that the Kansas Supreme Court said in the McAllister opinion was that that's one of the prongs that we consider is is drafting this type of language. I mean, for example, one of the concerns that I have is that the ordinance itself as drafted touches on some of the zoning text amendment, but not all of, which creates a gray area that is sort of unclear and would be difficult to enforce because it leaves out some definitions that existed, but then it supersedes the entire text amendment on its own. And so that's one area that the Kansas Supreme Court has identified. That's why administrative function is reserved or is outside the scope of the ordinance petition mechanism, because the people who are drafting these type of zoning ordinance have to be able to take the existing zoning code into account and make those amendments and changes to make sure that they adequately can coexist with one another, right? So if all zoning regulations or specific types of zoning regulations were allowed to be processed through the ordinance petition mechanism, then you may very well get a lot of conflicting zoning regulations that don't necessarily align with the comprehensive plan or all these different things that there's a specialized knowledge about internally, because that's people's jobs day in and day out, is to plan and predict and work through those things.
So with this petition, they're talking hyperscale data centers and tier 2 and tier 3. Does that leave the other emerging technologies that we currently have in the zoning? Does it leave those alone? It only deals with those two?
Well, I think Scott can probably speak more specifically to the sort of gaps that I was talking about, but the way that the text is written is it specifically and expressly supersedes anything in the zoning code that would relate to the definitions that the ordinance uses. But the problem is that there are other definitions within our existing zoning code that aren't included in the ordinance, which is unclear what the impact of that would be on the existing ordinance. Because if it's adopted or put to a vote, it does become law, so then we've put a law in place that creates sort of a gray area around sort of the existing zoning code. Which is one of my concerns, is that if the commission's will is to effectuate what the ordinance petition asks for, which is an outright ban on these particular uses, then my recommendation would to be that we do that. We just do it by cleanly amending the existing code so that it's not in conflict with the way that it is currently drafted. Did I say that right, Scott?
Yep.
So, is there a reason why we could not work together as one group and say, well, we're going to bring all this together, find out where the specific areas are that there was major problems, and in the meantime say, nothing done until we get this fixed,
Yeah.
and then we can move on together. We do several things. Hopefully it gets the working us together now to get people feeling good about what's happening. You save money on a special election. There's a lot of things that are involved, because I think we need to work together to get all this done.
Yeah, so one of the options that that city staff has worked on in proposing is sort of that first one, which is declining to treat the petition on its face as valid based on the fact that it's an administrative use of the ordinance petition code or the ordinance petition statute, but instead of just saying it's not valid,
Yeah.
you know, go on, one of the options for the commission is to say, but we want to effectuate what you've put in here, we just want to use the appropriate legal vehicle to do it so that the city's not exposed to risk, so that there's not sort of this conflict between our existing ordinance and the ordinance as it was proposed. So what that would look like then is, what I think David and I support this, is to say, okay, then we put a moratorium in place to give that level of peace to say, this is something that we're going to do, we're not going to allow these things to happen, and then we're going to go back and amend the text to match the way that we can, the ordinance petition is drafted, to reach the same result. my hope of that would be is that then we reach out to council who drafted the ordinance petition and say, the ultimate result here is X, and the commission has given staff instruction to get X, but to avoid litigation and unnecessary expense on both sides, we just want to be able to use the legal tools as they exist to do that, as opposed to this mechanism.
And then what happens if we don't go far enough for his client?
Well, based on his position, in our email exchange, it is the city staring down, the deck action, which I told you about. I mean, it's a lawsuit,
Sure.
to attempt to enforce the ordinance petition as drafted. And then, getting clarity from the court to say, court, this is the way that the law is written, this is the Kansas law that exists on the matter, this is how we interpret it. If we're wrong, tell us and we'll do what you say. If we're right, tell us and we'll do what you say. But we're sort of in this position where we don't want to step one way or the other and be wrong.
Sure, but we could essentially be back here, right? If we're like, hold on, we're gonna try to negotiate, we go back to zoning, planning and zoning, and do whatever.
Yep.
And it's still not far enough for his client, then we're back here potentially again.
Yes.
Right.
If the opinion of this attorney and/or his clients and/or whomever is in charge of what happens next, if their opinion is that this is an appropriate tool under which to use the statute and nothing that can be done on this commission's end one way or the other they will agree with that, then they may just file a lawsuit either way.
Okay.
Yes, we may just end up right back here.
So when you say there's going to be negotiations, who basically does the negotiating?
Well, it's not necessarily negotiations in the sense that, we go back and forth. It's more, hey, we don't believe that the legal mechanism or the legal vehicle that you've used to present this to the commission is the appropriate one, and therefore we believe that it is invalid. But as opposed to going to court to argue about whether or not it is valid or not, we would propose to put a moratorium in place and then draft the zoning text in a way that aligns the existing zoning code with what the impact of the ordinance petition does. Now, that's not to say that we can't work with the attorney who is drafting it to say, these are the concerns we have, or this is what we're planning in place. That's something that's totally appropriate. I just don't know whether that attorney stays involved or not, so I can't really predict what that looks like. But the process from the city's perspective is to direct staff to draft an ordinance, essentially, if this is what the commission wants, to say whatever the end result of this ordinance petition is, the banning of the uses and the tiers, we want you to amend our zoning code to reflect that. And then that's what city staff will do. Now, obviously, there's no mechanism which I can guarantee an outcome because, due process. So what that looks like is going to the planning commission, it gets proposed to the planning commission. The planning commission is told, this is the direction from the city commission, this is what the direction that the ordinance was to say, this is a public hearing, and then it comes to you all for a vote.
Is there any kind of typically a time limit post on that?
Yeah, so there's 20-day publication prior to the public hearing for planning commission action. And then after the recommendation, there's a 20-day protest period before it comes to you. Essentially what the protest period does after a recommendation is trigger supermajority of the city commission. Those are rare and more, I think I've only had one of those in my career here. But I wouldn't imagine something like that coming to light in the situation with the text zoning amendment.
I got some initial thoughts. I mean, first, I think that a declaratory judgment is wise to verify whether or not this is an accepted legal method to propose this new ordinance. And like you said, if it is, we accept it, we roll with it, and we move forward. But what I don't want to happen is allow this to go through and then face legal repercussions in the future from doing so because it was not the correct legal method. My other concern is the 10-year lockup on this ordinance and the gray area that this creates. My primary concern in doing so is we've all read the stories of high-powered attorneys representing these companies bulldozing local ordinance, local rule, right? So if we accept this ordinance as petitioned and we determine in the future that is not the legally correct method for doing it, and it creates a gray area in our current ordinance and zoning regulations that then allows some high-powered attorneys to come in here and just bulldoze straight over it, what did we do all this for then? I mean, I think that that creates an outcome that nobody wants on either side of this argument. Beyond that, I am indifferent on data centers. I have had many conversations on them. I have read into them enough that I think that I can understand the risk and the reward that comes with facilities like that. Beyond that, all the conversations that I've had are either folks that adamantly oppose or folks that are indifferent to even slightly in favor of a development of this nature. And generally what I like to do is play a little bit of devil's advocate just to explore their thought process further. And generally when I do so, what I have heard from both sides at the end of the day is, well, if we aren't so sure, why don't we allow a public vote? Which I am not opposed to. I understand that we don't and shouldn't have a public vote on everything because then it becomes a slippery slope on, do we have a public vote on what streets get redone? Do we have a public vote on what time the streetlights kick on, right? But on a topic that is as hotly contested as this one, I think that it would be fair to allow the community to have a vote and have a say on what is put in place. Now that being said, if we go to with the deck judgment and it's decided that it's legally invalid, then I would want to bring forth an ordinance to be voted upon in the general election on whether this is allowed or not allowed, and allow the public to have that say. Beyond that, if that is the direction that we go, the direction that I want to go, we establish a moratorium until election day to ensure that nothing slides
I think those options are doable. The only warning or caution I would give is that the same mechanism that exists to say the way that these zoning laws are created are administrative means that the way that the vote is put out is that it would have to be drafted in a way that is an advisory, because what we can't not do is in one breath say the mechanism for the ordinance petition exists only for outside the scope of zoning, and then turn around in the same breath and say, but we will allow that mechanism in this really narrow way by allowing it to go to public vote. That's not to say that you shouldn't have a vote. That's not to say that you shouldn't commit to doing whatever the vote tells you to do. That's the point of it. I would just caution that the legal basis for saying the ordinance petition as drafted does not allow for this to be the vehicle to make zoning law is the same legal argument that would be made to say a vote as it comes, when it's put out, is a vote where the commission is saying, we want clarity and direction from the community on how we should vote on this particular issue. Does that distinction make sense?
Yes,
Okay.
yeah. Which I like to think that the vote would be honored.
I do
If
too.
that's, if
Yeah.
that's what it comes down to.
And that would be my recommendation, is don't put anything to a vote that you wouldn't be willing to listen to.
Right.
But, just for, again, I wouldn't be doing my job if I didn't tell you that for the distinction of, the vote, the way that it exists is, would be to say, this mechanism in this vehicle is not the legally appropriate one, but we do want to offer the opportunity to get complete clarity from the community as a whole.
So you're saying the vote would be advisory, not binding?
Correct.
Wow.
I mean, advisory and not binding in the sense that the whole point here is that if the commission is inclined to make a binding, have the community vote on a decision that is binding, there is no reason to take the position that this ordinance petition mechanism is legally improper, because you're essentially creating what the ordinance petition is designed to create. My concern with that is that that is not a proper legal vehicle to make zoning law. So the proper legal vehicle to make zoning law is to follow the statutory framework that exists for zoning laws to be created and instituted and implemented. Now, if the commission says we want to understand what the public wants, then the commitment would then be, we're going to have a vote, we're going to put it on the ballot, and we're going to see how it shakes out. And if the majority, and it not, there doesn't have to be a threshold, but if the majority of that vote shakes out to say that we want all of these uses banned, we want an outright ban, and this is what the concern is, then my advice at that point in time to this commission, or whomever is sitting in these seats, is to say, you need to honor that commitment. Whether or not it is legally or technically binding is relevant to the way that we get there, but it is the most appropriate thing to do, is that if you're going to put it to a vote, you agree that that vote has power. Otherwise,
You
I think
wasted
any
your time.
credibility that may otherwise exist
Right.
is certainly eliminated.
One of the things that I heard you mention, I believe in the McAllister case, was that part of why zoning is considered administrative is because there's a lot of technicalities that go into the decision-making, right? Or not the decision-making, but the text that's presented to the governing body, okay? And I may have missed it in this response from the attorney, and if I did, I apologize. But with that being said, that this is all very technical, it's put before us, it involves a comprehensive plan, all the things that you've already spoke to. Where did this arbitrary information come from? Did he make any mention to that? I mean, so even, I mean, we task staff and we vote on a lot of ordinances up here, and those ordinances are thought through the lens of how we as a commission have directed to the city government to go, for the city to go. That therefore goes to Scott, who is very good at his job and puts in a lot of work to make sure that ordinances are thought through when they come to zoning, and he presents those to the planning commission, and people have a opportunity to speak on those. In subjects like this, they have multiple opportunities to speak on those. And so I struggle to adopt an ordinance that can't be changed for 10 years that's kind of arbitrary in nature, even if we were to determine that we didn't want to fight the legality of it. This has nothing to do with the layout of how we typically do business going forward. And not knowing how these numbers, how these definitions got put in here, I think that would just be bad policy on our part to adopt something of that nature.
Yeah, there was no, let me say it this way, I don't know how the terms were come up with, I don't know how the tiers were determined. I don't know why some of the definitions in the existing zoning code were left out entirely. I don't know the answers to any of that, or how it was ultimately directed or researched to be drafted. And I would echo that that's part of the reason that zoning work is typically is reserved for not using it through the petition ordinance mechanism, is because it does take technical work to make sure that two laws that you create can coexist with one another and not be in friction.
So I mean, I think from my perspective, I agree completely with really a lot of the conversations happening up here. I want to kind of touch on what you said, Commissioner Scribner, and that's, I'm just trying to understand kind of some of the arbitrary nature of some of the pieces as it pertains to how these are defined. The tier 1, tier 2, tier 3 battery energy storage systems. Of course, the data center, high impact data center definition, and really trying to understand that. I mean, you know, the reality is if somebody has a whole home battery backup system in their house and they also happen to drive an electric car, they're going to have potentially over 80 kilowatt hour battery storage, which puts them in the tier 2, and so they wouldn't be able to run their air conditioner and charge their
Yeah.
car at the same time. So I'm just kind of curious kind of how this was defined, but I mean, I think that it's, to Commissioner Tipton's point, I think that there's an opportunity here to find the right path forward. The 10 years bothers me. I mean, if you read anything that everyone's posting out on social media, it's that these data centers are going to go away because technology changes so fast, and so it tells me that there's the potential that things change, and which is the reason that we put the zoning text amendment in place in the first place, was so that we could protect the community from a data center coming in and not having any say or any control in it. B, it would allow us to put conditions and allow us the opportunity to say no if we wanted to say no, if we needed to say no, say yes or say maybe if it meets these certain conditions. That's the power of a special use permit. But you know, this is where we're at today. I don't want us to you know, I don't want to put the city in a position where we're you know, moving on its face, at least moving this petition forward and then putting that process in jeopardy for, to Andrew's point, you know, maybe these high-powered lawyers that we keep hearing about from the data centers that are taking over cities will come in and, you know, just really erase our zoning challenges or our zoning regulations that we have now. So what I would want to do is, if we decide as a group to move down that path, would be to get a declarative action on this specific petition, get a moratorium in place so that nothing happens in the meantime, understand what the definitions are and how this is defined, and then get something on a ballot so that we can, I mean, if that's the path that we want to take, then get it on the ballot so that we can see what the community's feeling about
If we choose to go forward with getting the legality of the petition, the current zoning law as it's admitted, as it's in today, stands, right? Which would, should a proposal come, it would have to go through all the permitting and hearing processes.
That's correct.
Yeah.
Okay.
And, well, go ahead.
Well, I was going to say right now, to me, right now as the petition stands, I don't that does not need to go to a vote. We need to do something between that and what we have before we even think about that. I know you said David was going to say something about a moratorium and how he saw that. I believe in working together. I believe we have to work together. But I also think that both sides have to come to the middle and meet. We cannot stay totally on.
Hey,
So basically, you're saying you're not willing to work with us?
Release the Quora records and we have the information we need.
Put it to a vote, if we're wrong, we'll accept it.
I don't. We need to continue our conversation.
We tried to work with you.
Then I would suggest,
We can't have a meeting.
Take the
There is no
gavel.
public comment. I understand that you guys have strong feelings about this. This just is not the venue in which to make them sitting from your seats, yelling at them from across the room. I understand that you want to be heard. I understand that you stood up here and made commentary, but these people who are up here trying to do the best they can deserve the respect for the ability for you to just let them do the process up here without yelling at them from your seats. That's all I'm asking. So thank you so much. If you cannot commit to the rules of the procedure in which that we're having in here, you don't have to stay. Go ahead, Commissioner.
well, I was willing to work, but, I mean, if we're going to just hit a brick wall, I'm not quite sure now what I want to do. I just know it doesn't need to go to a vote the way it's written.
The way it's written.
Well, I think the first thing that needs to be determined, if I understand, is it even a legal petition? From what I understand, they're kind of two separate issues that are somewhat hand in hand. But I think it would not be good for us, speaking as one, as if we didn't solve the first problem first. And then once we have an issue for that, we can determine the best path going forward.
Yeah, I don't want to conflate the issues. The first issue is that whether or not, the threshold issue of whether or not this particular type of ordinance can be, whether the ordinance petition vehicle can be used to effectuate what it is attempting to do. My recommendation is that Kansas law says that it is not, and if that is something, if the commission, even if the commission says, I'm fine with the ordinance as drafted, my recommendation would still be to go to the district court and say, hey, district court, we're not totally, we don't think the law allows it to be this way, but we've got a community of people who do want it to be this way. So why don't you go ahead and rule on what the rules are and how this law is going to be applied to the specific ordinance, and we'll do it. But that way, when we, if and when we ever get sued for doing it the wrong way, we've got the legal cover of a judicial ruling saying we did what we were told to do based on the way that the court has interpreted the way that this ordinance petition and the way that it's currently drafted exists. So it's, I don't want it to sound like we're taking some hugely adversarial position as it relates to getting a declaratory judgment. It is more, Judge, the law is in conflict with the way that this was presented versus the way that the law exists. If you tell us how you interpret the law, then that's how we'll interpret it. But in the meantime, we'd be what I believe to be in conflict with the way that Kansas law exists. And the judge rules, and there's not a winning or a losing at that point. It's just clarity from the only body that is allowed to give clarity on this particular topic. So I would agree that the first sort of threshold issue is the decision about whether or not this commission wants to take that approach and say, let's go ahead and go that way, or whether the ultimate decision is to say, all of that aside, Ashland, I think we're just going to make a decision whether, if it is valid, then we'll move on to whether it is adopted or put on the ballot. But it cannot be changed once it's deemed valid, then those are our only two options. There's no changing, there's no revising. It is adopted as written or it's put on the ballot as written. So, yes, in short, one issue is separate from the other.
So we can decline to treat the petition as valid and respond or ask for an injunction, to find out whether it's administrative or whether it's legislative.
Right. So it would be, the decline, or the commission declines to treat the petition as valid based on Kansas law and the concerns around the way that the statute exempts out administrative. Then if your next step, and you could decline to treat it as valid and leave it there and do nothing. That is an option. Not an option I recommend. I would say that the best option would be, if you are going to decline to treat it as valid, that we make sure that that was the appropriate approach and say, hey, court, this is sort of the position that we're taking. What we likely would do is ask for the ability to have the court rule on that, and make a decision one way or the other. And then whatever the ultimate decision is from the court is how the city proceeds to act.
So, we want to, I agree with him, I want to vote. The kicker here, though, is you're going to have everybody, who's going to have the final say-so on how the vote's written on the ballot? Does that make sense?
It does make sense.
Because that's what's important, because if you give them a vote and nobody's happy with the way the ballot question comes out on the ballot, everybody still loses.
Mm-hmm.
It has to be something that everybody can agree on, that when it shows up on the ballot, they feel good about it, that they're going to be treated properly, and we feel good about it, that we're going to be treated properly. That's the working together that needs to happen here.
Certainly.
You know,
I think, Leon, I think that's where the zoning and the public hearings come in, right?
I agree.
They were presented, planning and zoning was presented on the first meeting, a amendment to the zoning code that after the first set of public hearings was sent back and tightened up based on the feedback that was given to them. It was therefore, they had another chance to hear. They still felt like it was a comfortable solution to zoning to present to us, to which we agreed with them on. So I feel like that process has already happened. Are we gonna make 100% of the people happy 100% of the time? No, but that's why there's processes, you know? And if everything has to go to vote, where does it stop? Does it stop with a development? Does it stop with, there are mechanisms that are put in place that allow people to present their concerns, to present their support, that is therefore considered in the grand scheme of the city and in the direction that we have asked David and Scott and the other boards to move the city forward, and they make their recommendations based on that, and we either need to stand behind that or we don't. And just because there are people that aren't happy with it doesn't make it bad policy within the framework of the city.
but we've seen a group of people who have not been happy with it.
Sure,
And so when you're not happy, what do? You complain.
sure.
We're the group they're complaining for. So we've gone, I think I've served, this is my 6th year going on the board. First time I've ever seen this roll around. That tells me there's something out there that we need to take care of, that they're not happy. I hear you, but I think somewhere along the line, you gotta say, when something that comes along this big, you gotta say, whoa, we gotta do something different.
Yes.
And I think this is it.
I just don't want us to make bad policy under the guise of doing something.
I will
And I think
argue
that
that.
that's what we see governing bodies do a lot,
And
and
if-
that is my biggest concern.
And if I was on the zoning board and I heard this, I'd be unhappy. Because I would be saying, hey, they're not happy and they're gonna be overruled up here. What the heck, I'm spending my time up here. But there still comes a time when you gotta say, you gotta do what you gotta do. I think you gotta give them the vote. That's me personally.
I want to be really clear here, because it matters, because we're taking a position and you're talking about two things distinctly, and I do not want them conflated. Either you legally, you agree with the legal analysis that zoning decisions as it relates to how laws are made, as it relates to zoning and zoning ordinances, is not up for public ordinance drafting and vote. That is either true or not true.
Okay.
Now, that is not to say that you can't say this is not a legal and valid mechanism in which to make zoning law, but we are happy to have a vote or a poll or whatever mechanism you want to exist for city staff to put together and do in order for you to get clarity about what the whole community thinks. That is an appropriate thing for the commission to do. But what will be difficult is if you ultimately give staff direction that you don't believe or that you agree that the law as it exists does not allow for zoning ordinances to be determined by community vote, and then in the same breath say we're going to do a community vote, then we're standing in front of the judge with two conflicting positions on the record, and that doesn't make our jobs any easier down here. So I hear you, and I can make, city staff can work to make both of those things true to a degree, but I want to be abundantly clear that the position is that this vehicle that either allows for outright adoption or a public vote as the ordinance is drafted is not, my recommendation is that it is not the appropriate vehicle in which to make zoning law. Now, your question was, how do we make sure that if we are going to put something on the ballot, that it meets, that it eliminates sort of the overarching concern so we're not right back here? The truth, Commissioner, is that we can only do the process as the state statutes have allowed the city to make and do zoning law. What we can do is ask about whether or not people want an outright ban on data centers, whether they want discretionary zoning text as it exists right now, but the actual language as it relates to what's going to go into the ordinance is it's not appropriately put up for a vote, the ordinance language itself, because the legal position that I understand that you are telling me is that that is not up for public vote. That has to be done internally with the technical use and the technical understanding and to make sure that it matches the existing text code. That is not to say that the city can't work with the individuals who have largely put together this ordinance petition to make sure that the zoning code matches in a way that gives
You're saying
comfort
after the vote. like
after the vote, right?
After the vote, then you listen to what people say, and then you work together to make things work.
Well, that
You
would
hope.
be great, yeah.
You hope, but please understand, if you get the vote and and it doesn't come out right, where you at?
And
Today you accept it.
I think-
Do you do tomorrow?
She's done. This is conversation, but I get it.
yeah, so, and I only bring that up because I want to be
It's a good
clear, if that the vote is a separate advisory vote to advise the commission and city staff on what the process is or should be, or what it should contain and or look like. I don't want to both take the position that this is an administrative function that is not up for this type of
It's not up
procedure
for
and then give them, and then we would truly just be going in circles.
Right.
Anything else?
I stand by what I said earlier. Every bit of it. Yeah.
Okay. So, at this point, you know, unless there's more discussion or conversation, or I don't want to leave anybody out if there isn't, but I also want to make sure that we're moving things forward if it's the way that you want. So, my threshold question would be, to the extent whether or not the commission would like to agree with and or accept my recommendation is that the petition ordinance as drafted currently, because the text of the ordinance itself specifically refers to, relies on, and uses the zoning code for enforcement, say that this mechanism in which was used to bring it forward is not a valid legal mechanism in which to pass the law. I think that's the threshold question that I need direction on, and then what happens after that.
So you need a motion from us to instruct you to ask the courts to decide or to declare that the petition sits outside of the scope of 12/30/13 in May, and then ask the court to pause the 20-day clock while it decides.
That's correct.
That's what you need from us.
Yep.
So you need that
Mr.
motion.
Chairman, I so move.
Wait, hold on.
Oops.
The thing that I was gonna add is that if that's a direction that the commission wants to do, we can also do a moratorium tonight, so between now and whenever there's a decision, whether that be from the court and or from the election, the moratorium can extend during that duration. So, real briefly, I can go over this, and then the commission can do with that as it will. But what we did is we took Sedgwick County's moratorium, modified it to reflect the language of the citizen-initiated petition. And so basically what it does is it says, and there'll be copies of this available as well, but first it provides a temporary suspension. So within the corporate limits of the city bill radio, there would not be any conditional use permits or building permits for applications submitted after the resolution's effective date, which would be the date of adoption. That would include or involve high-impact data centers or Tier 2 battery energy storage systems or Tier 3 battery energy storage systems as defined in the resolution. The definitions of a high-impact data center are taken from the ordinance that was included in the petition, but so everyone knows what those are. A high-impact data center is defined as a principal use consisting of one or more buildings, structures, or facilities whose primary purpose is the housing, operation, and maintenance of computer servers, data storage devices, networking equipment, and associated infrastructure for the bulk processing, storage, or transmission of electronic data that requires a peak electrical load exceeding 10 megawatts or a daily water draw exceeding 100,000 gallons. This term includes server farms, co-location facilities, AI training facilities, cryptocurrency mining operations, and similar high-density computing facilities, provided, however, that high-impact data center does not include accessory data processing equipment that is incidental and subordinate to the primary use of the building. A battery energy storage system shall be defined as an engineered facility that is capable of charging batteries from an electrical transmission system, storing the electrical energy, and discharging the electrical energy to later re-energize the same system, and does not include a power plant or other manner of generating electricity for distribution or storage. A Tier 2 battery energy storage system is defined as an energy storage system with an aggregate energy capacity between 81 and 600 kilowatt hours, or are comprised of more than one energy storage system technology in a room or enclosed area. Finally, a Tier 3 battery energy storage system is defined as an energy storage system with an aggregate energy storage capacity greater than 600 kilowatt hours, and if in a room or enclosed area consists of only one energy storage system technology. So those uses, high-impact data centers is defined, as I just read. Tier 2 battery energy storage systems and Tier 3 battery energy storage systems would be suspended, if you will, until, well, from the effective date of this resolution until November 30th, 2026. The resolution does state that it can be extended as needed if a decision is not rendered by that point in time. However, when we drafted this, we looked at a general election would take place on November 4th. November 30th would give us a cushion for certification of ballots. And so that's what we came with the November 30th date. It's basically that general election plus some basic. It would apply also to the extraterritorial jurisdiction of the city to the extent that the city's adopted zoning regulations and building codes apply to the development within the properties located within the 3-mile area surrounding the city. So the extraterritorial zone is an interesting situation because the city does the zoning regulations, but we do not issue the building codes, is that correct? Or we
We
don't?
have land use only.
Yeah. So there is some question with that. So that can be adopted tonight. It would basically call timeout on any potential development of any of those uses that I've already read, to allow this process to kind of clear all those hurdles that we've already discussed, as the case may be.
I also, sorry, if you have questions for David, I just don't want to lose my train of thought. In sort of the spirit of working together and making sure that everybody's sort of positions or things are concerned, one of the things that I will also do is, to the extent that the attorney who has drafted this ordinance petition, if a moratorium is put in place, and if that's the direction the commission decides to go, and a decision is made in the interim, one way or another, what I may do is say, would you, on behalf of your clients, be willing to withdraw the petition to avoid the need for litigation, to save everyone the expense, while the city works on either adopting zoning code or preparing an advisory, sort of ballot to poll, whatever you want to call it, to sort of eliminate the need for the expense of that. I don't know what the response to that will be, one way or the other, but I will certainly propose it prior to filing, just to try to see if that's a mechanism that will be okay. If it isn't, I'll certainly let you all know. But it is an option depending on, because in order to have a declaratory judgment action in the court, there does have to be two sides. Like, it's just sort of the way that the process works. So we would have to name a party in the case, or if they file, they would name the city as defendant, and then there would be two sides taking a position. To the extent there is an agreement among both sides, then there is no need for litigation. So.
Well, I don't want there to be extensive litigation, but I also think this is an opportunity to help define and help us make sure that
Certainly.
our approach is correct.
Certainly.
Is what the declaratory judgment would be.
Okay. Did you say everything you wanted to say about the moratorium?
I believe so. Does anyone have any
So-
questions with respect to that?
So are we ready for a motion on the first part?
Bef-
So go ahead.
Yes, so on the initial, what I want to make sure that the motion is clear on is the result of the deck action, if it is or is not valid. My preference would be is that if the court says, no, this is an appropriate mechanism, an appropriate vehicle, we're gonna give an exception or clarity around the way Kansas law is drafted or whatever, that my question for the commission is then, because it matters to the motion, if that is the ultimate order, then does the commission want this particular petition ordinance to come back for adoption or a ballot measure? Because how you propose the motion is what happens after court is over. Does that make sense? So if
the court decides that it is valid,
correct.
then we've got the two options that are presented in that in that statute.
If you want to reserve those two options, then you need to say so, yes. As opposed to saying, without clarity, then when the court says, yes, it is valid, then we just want to make sure that it's not
Okay, I guess.
adopted
Okay.
or,
I mean, from my perspective, if the court says it's valid, then we need to send it to the ballot.
okay,
I mean, that's my
Right.
my belief, but that's just, if the court says it's valid, and if they say it's not, then we put together another ballot question of some sort
Okay.
after we put, when we put this moratorium in place.
okay. If, that is the motion up for ballot, or up for vote, then we'll just want to make sure that that part is clear. That would be the process after the court has weighed in.
Okay, so I'll make a motion and then you can make sure I hit all the points. I move that, based on the advice of the city's council, we declare the petition invalid, and we ask for a declaratory judgment within the courts, and based on that response or that decision, it will come back to the commission for the opinion to adopt or send a vote to.
Second.
Motion and second. Any further discussion or questions?
I'm curious, in the motion, it didn't say anything though about the suspension.
We'll do
We'll do that
We'll do
second.
Oh, that'll be second, okay.
Yep, good question.
Any other discussion? All those in favor say aye.
Aye.
Those opposed, same sign. Motion carries 5-0.
So then to adopt the moratorium as I've just described, you'll just read motion to approve and then the resolution title right there.
One question on the
Oh, okay.
moratorium. Should we just, for clarity, go ahead and say, Article 3 within the city subdivision reg, or zoning regs, define data centers and define battery energy storage?
In the language of the moratorium itself,
Yeah, should we just add that at the end, since their definitions are different than ours?
oh,
Wait, we could change real quick.
okay.
Or did you?
Oh, no, I didn't.
So Scott, you said.
Yeah, and say, just at the end, add and Article 3 of the City of El Dorado zoning regulations, data centers and battery energy storage systems.
Write it so I can read it.
Well, good luck with that.
Say it one more time, Scott.
Article 3, the city zoning regs, the battery energy storage systems and data center definitions for the moratorium as well.
Okay, so I have, I'm just gonna read it so you can read my handwriting. A motion to approve a resolution establishing an interim development control and providing for the suspension of certain types of use applications and the building permits in consideration of any land within the corporate limits of the city of El Dorado, Kansas, and applying such interim development controls to Article 3 of the zoning regulations, definitions of data centers and battery storage systems.
I'll move to approve.
I'll second.
Motion and a couple of seconds. Any further discussion? All those in favor say aye.
Aye.
Those opposed, same sign. That was 4-1. Yeah. Sorry, script, I didn't, I apologize.
It's okay. It was loud.
It was close. Okay, what else you need from us? Do I have a motion to adjourn?
So moved.
Motion and a second? Do I have a second?
Second.
All those in favor say aye.
Aye.
Those opposed, same sign. Motion carries. Thanks, everybody.
Weird.
I didn't.